Is it the oppression and criminalization of the young black male? Can it get to intent? And how can it be used in the courtroom, right or wrong? So I open up the floor for questions, and please ask our speakers. Come on, you guys got to have something. This was pretty provocative.
I actually have a question regarding the use of rap lyrics, particularly with the idea of threats in mind. I guess this would be an ignorance on my part of how it's used within the specific legal setting, but I know that, say, in the example that Charis, you've given, was that it was something that had sort of specific detail referencing, my bank account, and then, the comparing it to the Virginia Tech shooting, that sort of thing. So how much does that sort of level of specific content or focus on a particular individual versus just speaking in generalities? How much does that get into the role of determining whether or not it is considered a threat versus just speech? I guess?
That's a great question. So first, let me preface my answer by saying there's really two ways in which rap lyrics are used as evidence by prosecutors. First is by actually the individuals charged with a crime, whatever crime that may be. The lyrics are then discovered during a search or something and brought in as what amounts to character evidence, even though, as Dean Chemerinsky mentioned, that is not technically allowed, but that's what gets conveyed, right? To support sort of, this is the kind of person that could do this sort of thing. Most of the time, these lyrics have absolutely no bearing on the crime that the individual is being charged with. So there is very little correspondence whatsoever. In the cases I've testified in, and the cases that we talk about in the paper, there is almost no correspondence between the lyrics and the actual events of the crime. And that's what's very troubling to me. I have not yet encountered a case where I've been asked to comment or testify in, although I know they exist, where what the raps reveal are very specific details about the crime itself, right? The date, the time, the event, the victim's name. That is, I think, the exception rather than the rule. The second instance is in the case of Odewale, where the lyrics themselves constitute the entire case. The lyrics are, as I say, standing trial. And there you have no other crime than the lyrics themselves. Okay, right? I mean, he did possess guns on a campus, and he copped to those charges, and he pled guilty to that, even though he was the legal owner of these guns, and there were no issues to that. But this entire case would not have been, had it not been for the lyrics themselves. So I'm not quite sure if I answered your question directly, but it's that they're kind of different in the way in which lyrics are used, and here, there's no corresponding to anything because no event happened other than the lyrics being created, identified, and then tagged back to a potential threat.
Can I ask a related question? So then how is the decision made? I mean, my knowledge of the law is like, I watched The Wire. So is it in the jury's hands here and they're advised by the judge? Or is it the judge that would say, well, no, this is not admissible or not? So then, I mean, if there is this kind of pretty clear dissonance here, it's still happening.
The jury gets to decide only questions of fact. Any questions of law are decided by the judge. And the judge has to conclude that a reasonable jury could conclude either way to allow the jury to then decide that question. I mean, if the judge, for example, says no reasonable jury could conclude that this is a threat, then the judge has to dismiss the charges against the defendant. So I think in terms of the former, which we should just say, I think that all of those examples would be impermissible use of the evidence because it's about character, and the judge's role is to exclude that. That shouldn't come in at all. The judge decides what evidence the jury is going to hear, and I think that there it's impermissible. I think as to the latter, whether something is a threat, that becomes a much harder question. If somebody says in just spoken words, I'm going to detonate a bomb at the Super Bowl, and it's a reasonable person could fear of it, that's not speech protected by the First Amendment. It doesn't become protected by putting it into rap lyrics, if it's the exact same words. And so then the question is this a true threat? the Supreme Court hasn't said much about what's the standard for true threat. It's what a reasonable person perceive it to be. That's really the jury question. And there's always problems, as we're talking about, and having juries make cross-cultural determinations of this sort. But that's the question that would go to the jury, the factual question.
One thing to add on that, which was that the note, the 6 lines of text, the threat, however it's talked about, was actually found in a console of a car that was left abandoned. And so one element of communicating a terroristic threat is that it must be communicated. Now, the prosecution claimed that the car being abandoned was an indirect way of communicating the threat because Odewale was well aware that the car was going to be found, that it was going to be searched, right? So originally, there was a lot of claims to have the case thrown out because no threat was actually communicated. So there's many different layers going on here, but at the end of the day, the judge allowed the lyrics in, and the case went forward.
Question in the back.
Forgive me if I walked in a couple minutes late. I may have missed some of the statistics, but I was wondering what the difference is in terms of lyrics being introduced in the courtroom between rap and another genre. One case that I can think of is the West Memphis 3. Back in the day where the prosecutor used the fact that they looked goth, they listened to heavy metal.
Right.
How often does that happen versus rap? And in a number 2, following up on that, we talked about 1988, the Fuck the Police. Had a heavy metal band done the same thing, would there have been a lot less reaction, or do you think it would have been similar?
Maybe I'll take the first one, and Sohail, you want to take the second one? Okay, so the first one is, first of all, the universe of numbers has not been well established. So, for example, I can't tell you how many times rap lyrics have been used as evidence in criminal cases. We are in the process of trying to amass a database that can tell us just that. However, what we do know is we can look back to court cases, and legal scholar Andrea Dennis, who I mentioned during my talk, who really is one of the first people to start investigating this issue, she did an analysis and found only one case, and perhaps it's the West Memphis 3 case. She doesn't actually say which case it is in her paper, but found only one instance of a case where lyrics, defendant authored, no, actually it's not that, because this is defendant authored lyrics, were introduced as evidence. Only one case that was not involving rap music. So the point is that this is unique to rap music, absolutely unique to rap music.
If you could just ask your second question again, please.
Oh, I was saying, going off of that first one, they were talking about how the prosecutor used heavy metal in that case against the defendants to kind of define their personality. You were saying that in 1988, when they came out, the 2 Live Crew, and it was Fuck the Police, would there have been a similar reaction if a heavy metal band came out, or do you think it would have been completely different?
Right. Well, yeah. So it ended with NWA, and that's a good question. I mean, I think one thing I want to do is go back to the point that Professor Chemerinsky was making about the admissibility of evidence. Like, in terms of a judge, would a reasonable person see something as a threat? And what constitutes a reasonable person? and how is that reason constructed? So that if I were to say, I'm going to go blow up behind a bomb at the Super Bowl, based on how I look in the context of the war on terror, a reasonable person the judge would say a reasonable person might say that that's an actual threat. Whereas if a white woman were to say it, a judge might say a reasonable person wouldn't believe that that's actually a threat. See what I'm saying? So who's a reasonable person? How do ideas around race inform who and what is a reasonable person? I mean, this is historic. It goes back to the very Enlightenment idea of who is a reasonable human and who is irrational. The non-white was seen as irrational and savage. White is always presumed to be reasonable. So there's always been a historic relationship to this, epistemologically. But I'm saying that even in the current context, who is a reasonable person is shaped by the world that we're in. Right? So that's just something I want to throw out there. That's important to consider, right? But I think so that when we talk about NWA's song, I mean, Professor Chemerinsky pointed out the Cop Killer song by Ice-T. Now, how many people heard that song? How many people heard Ice-T before? Boy, you probably know him as the actor, maybe. So Ice-T's a rapper, right? Right? But when you hear the Cop Killer song, what does it sound like? It's a heavy metal song. He played with a full live thrash metal band. It's not him over a beat, typical hip hop, right? It's a thrash metal song. Yet, again, because it was Ice-T fronting a thrash metal group with a song called Cop Killer, it brought the specter around blackness into this conversation. So that all of a sudden now this became a song that needed to be contended with, right? And so your question about would it have been done to a kind of a white heavy metal band had they made the same song? I mean, that's open for debate, but I think based on what Sharis is saying and what we've come to see is that overwhelmingly, disproportionately, almost without exception, it's been the case that it's been hip hop music that has been put on trial, and rap lyrics and rappers themselves, right? And so I think that's important to keep in mind. And I think one more thing I want to close, maybe my comment was saying. I mean, again, we're asking about the admissibility of lyrics into the courtroom, right? And that's the fundamental question. And those are important questions. But I'm also wanting us to think about is like, should we prevent the lyrics of being admissible in a court of law? Well, to me, a better question and a more systemic question is, should we be having black and brown bodies continue to be tried in court? Why are they continuing to appear in court? And then prisons, disproportionately, overwhelmingly. That, to me, is the better question. Not the lyrics of some rapper who claimed, some wannabe rapper who's trying to come up, and that could be used to convict him. The more systemic question is, why are so many black and brown men in court? What are the conditions of possibility that make that a reality for them, right? So we can't see the courtroom, again, as this kind of sacred or kind of vacuum, a vacuum that we kind of like divorce from larger questions or systems of hierarchy and domination in society beyond it.
I had a couple thoughts about where the research might go from here, from where you are, and things that I would like to know more about. It strikes me that the central complaint being made here about the law isn't really about failure to protect First Amendment rights, because if Professor Chemerinsky's right, and I think he is, there really aren't First Amendment rights that are going to prevent prosecutors from using people's speech against them in trial. The central complaint is that judges are making inappropriate decisions about the admissibility of these lyrics and are allowing evidence that's in effect character evidence to come into the jury. And I think that's where more attention needs to be focused. Decisions about the admissibility of evidence, and particularly about evidence that might have the dual purpose, partly to prove some admissible point and partly might reflect on character, is a complex process. I mean, the judge first has to assess what is it relevant for some permissible purpose. And when we're talking about whether the lyrics reflect on people's making of a plan or having a certain intent or motive or their identity, it can involve fairly complex logic to connect it. I would like to know more about the litigation in trial about the admissibility of these evidence. In most cases, there will be hearings before trial, motions in limine, made by the parties on these cases. And in those cases, if the prosecutor is offering this evidence and the defense lawyer is objecting, the prosecutor will have to show a justification for what the relevance is. And I think it would be worth knowing more about that.
Yeah.
There's also the second and more difficult issue is whether it's prejudicial, right? So here the judge has to think not just is it relevant to a proper issue, but will the jury misjudge its relevance?
Yeah.
Do we know better than the jurors what to make of this evidence? And that's a complex psychological issue.
That very issue is what Eric and I are trying to think about in terms of when we get asked by reporters, well, what do you think about rap music? Should they ever be allowed in the courtroom? I agree that there's levels of complexity there that need to be acknowledged. On the other hand, I am not so certain that these lyrics aren't so prejudicial that they outweigh the probative value that we're talking about here. When you read the lyrics, when you hear the lyrics, when juries are presented the lyrics, and they're often long. I mean, in the case of Vontae Skinner, 13 pages of violent lyrics that are over the top. If you are not at all familiar with rap lyrics, these will blow your socks off. And the average juror, for better or worse, has no idea about rap lyrics. So the prejudicial impact, in my opinion, is so great that my gut wants to tell me in no instance should they ever be let in. However,
No court's gonna say that,
As
though.
a psychologist, I'm thinking you're proposing a testable hypothesis.
Yeah.
Right? And we can do, I mean, there's kind of a research genre on these jury simulation studies. that
Absolutely.
one could use
We
to
cite
approach
one
this
more
question.
study, we cite several studies in this paper. One of the studies we cite looks at the impact of introducing information to subjects in an experiment about a fictitious young African-American male. One group of subjects who's being charged with murder. One group of subjects is also told that violent lyrics were, that this individual had created violent rap lyrics. In the study, the social psychologist found that the violent lyrics were more persuasive for doling out a harsh sentence than was the simple fact that the individual was being charged with attempted murder. Okay, so we have this collection of social science research showing the prejudicial impact of rap lyrics, right, in these experimental studies. That's the question that I wrestle with: is the prejudicial versus probative value.
No court ever is going to say that rap lyrics or any other form of speech never can be introduced as evidence. Obviously, there's going to be some instance like where it's a blatant confession where it can come in. So I think the key is to come up with all of the ways of limiting when it can be used.
Yeah.
And this is why I think Bill's question becomes so important in terms of looking at what's been done and how it might be constrained in the future.
Well, and the one last thing on this that I'd like to point out is we've been focusing, and I totally agree with Sohail, that we need to step back and look at the larger context here within which this practice takes place. I mean, there's real life consequences for the individuals involved, and I don't want to minimize them, but at the bigger picture really is societal's treatment of young men of color and mass incarceration and all of the stuff we talk about in the criminology classes that we teach. But another important point that I'd like to raise is that I've focused in the talk on the use of them in trials. But what we're also discovering, which is not so well documented, is that rap lyrics are being used at early stages in the process to threaten defendants. Like, look, if you don't cop a guilty plea, you take this to trial, your lyrics will be used against you, and then you'll be really penalized. So there's different stages early on in the criminal justice system at which those lyrics can be used by prosecutors for a desired end. And we actually have no data on that.
If you look into it, you might find that defense lawyers are doing a rather bad job in those cases, defending their client's interests.
And it will be very hard to get data about that because
Yeah.
the plea bargaining process goes on in secret behind closed doors.
No,
And so it'll
absolutely.
be very hard to know the extent to which that happens. That's not denying it does.
Yep,
It should be very
no,
hard to
I
measure.
know.
I would be interested to know, in the cases where they have been admitted, how often does the defense file a written brief opposing admissibility?
Every single time.
Oh, okay.
I mean,
Well,
I don't have
Okay.
data on that, but that would be
All
my,
right, well,
my,
then-
Time for one more question.
yeah, sorry. Get us going.
Well, I think that gets me, the last point that Bill made about the attorneys gets me thinking about the whole color issue here, that if you're talking about criminal defendants, you're talking about people of color, sometimes they're being defended by people in public defender positions who are overworked, et cetera, et cetera, et cetera. So is one of the issues that the attorneys don't have the time or the skill set to deal with this as well as it could be dealt with in terms of rebutting the character kind of stuff?
It varies tremendously. I'm sure that's what you found in your own work. Some of these defendants have excellent lawyers, some have really terrible lawyers. And obviously the quality of the lawyering is going to matter when you're dealing with something as complicated as we're talking about, but it's very hard to generalize in these situations. But that's true of our criminal justice system. There's enormous variation in terms of the quality of lawyers, and the quality of the lawyers really matters in terms of the likelihood of getting convicted and the length of the sentence.
Well, I want to thank all of you for coming. I hope Quentin Tarantino never commits a crime. But I do appreciate you all being here. Please join us for a cocktail, some snacks, and thank you again. And please join us for all our future events. If you haven't seen our events, we do have a list posted, as well as get on our mailing list so we can let you know about our upcoming events. So thank you again, and thank you to our
Thank you, Max,
speakers
for
making
organizing.